Namaste, good morning. So today we are starting this 41 episode number 41 in this webinar series of AAA. And the subject continues to be the recap on landmark judgments of Hon'ble Supreme Court in the year 2022. In the last two webinars, part 1 and part 2, we have delivered the recap on judgments of Hon'ble Supreme Court, and today would be the part 3, and it is the final part. In fact, couple of judgments where this we have been discussing in the part 1 and part 2. We have seen that the proposed amendment, which was notified by MCA, Ministry of Corporate Affairs, for inviting comments, and that notice was on 18th of January 2023. And the impact of both these judgments, like Vidarbha Industries Power Limited and Rainbow Paper Private Limited, both these judgments, the impact is being diffused in the proposed amendments, so may not be applicable on any other case, as the adjudicating authority has also come to know the proposed amendments and also the intent of the legislature. So therefore, we in today it will be the last part for the Supreme Court judgments, and the next week on Saturday at 11 a.m. we would be taking up the proposed amendments in the Insolvency and Bankruptcy Code as per the notice given by MCA dated 18th of January 2023, and we will also deliberate on what kind of comments or what kind of additional requirements of any modification can be submitted to MCA. So we go ahead with this part 3, the Supreme Court judgments. I'll just share my screen. So we'll start with this Bank of Baroda versus MBL Infrastructure Limited. This judgment was dated 18th of January 22. Although the judgment is not having much impact because this judgment was on applicability of 29A on the promoters of a company, and apparently this was the first few cases of insolvency, and the application was filed on 31st of March 31st of March 2017, and the even this the section 29A was inserted on 23rd of November 2017, and in this case a decision had already been taken by the Committee of Creditors to seek a resolution plan from the promoters, and that decision was taken much before the insertion of section 29A. However, this decision which was taken to seek a resolution plan, that doesn't mean that the COC had approved the resolution plan. Approval was post insertion of section 29A. However, in this case, the adjudicating authority and the appellate authority decided that the promoters are eligible, and it was approved by 75% of the creditors, because that time the amendment of 66% had not come. So 75% financial creditors approved the resolution plan of promoters, and CLT and NCLAT also approved. However, the Supreme Court said in this case, why I'm doing a very quick view of this, because this impact of this resolution plan is not much on any of the future litigation. The observations of the Supreme Court in this case was that the promoter had actually executed a guarantee to secure the loans given to the corporate debtor, and the clause 29A, subclause section 29A clause H is attracted. The eligibility is restricted. However, it cannot be said that the personal guarantee was not invoked. In fact, it was invoked also. It was invoked also. So in this, like, what is the scenario? The scenario is that the Bank of Baroda was the only bank actually who was not interested in this kind of resolution, and everyone was interested. The Bank of Baroda had a smaller share, and the Bank of Baroda said that it is not possible for us to approve a resolution plan which is from the promoter. So it was only the Bank of Baroda who was fighting till Supreme Court. In fact, the other creditors, they got relief from IBCI and NCLT and NCLAT, and they the Supreme Court, the only Bank of Baroda went to the Supreme Court. Finally, the Supreme Court said that the adjudicating authority rightly noted that it was accordingly approved after taking into consideration the techno-economic report pertaining to the viability and feasibility of the plan. It was also observed by the adjudicating authority that the plan has also put into operations, and as of now, the corporate debtor is on a going concern. Further, the interest of over 23,000 shareholders and thousands of employees of corporate debtor needs to be taken into consideration. Rupees 300 crore has already been approved by the shareholders to be raised by the company. So the court said the clause H and clause C was applicable to this company, and the section 29A was inserted before the resolution plan was approved. However, the committee took a decision to seek a resolution plan from the promoters before even the section 29A was inserted. However, the Supreme Court said that the resolution plan submitted being ineligible is not maintainable. Much water has flown under the bridge. The requisite percentage of the voting share has been achieved, and majority of the creditors have given their approval to the resolution plan. Now, it was also said that the resolution plan has been implemented since long, and now you can understand that this particular decision has actually come in January 2022, and the resolution plan was approved in 2018. That is 4 years ago, the resolution plan was approved. The Supreme Court said finally the ultimate objective of the code is to put the corporate debtor back on the rails, and no prejudice would be caused to the dissenting creditors, as their interest would otherwise be secured by the resolution plan itself, which permits them to get back the liquidation value of their respective credit limits. So the Bank of Baroda was told that your interest is already protected as the dissenting creditors. So the Supreme Court finally decided not to disturb the decisions taken by adjudicating authority and appellate authority with regard to the approval of the resolution plan from the promoter, even if the promoters were not eligible at that kind of time when this section was just inserted. And basically the reason for this decision was because this company, MBL Infrastructure, was already as a going concern. It was already on a going concern. Now, another judgment, which in fact I thought that it may even relate to year 2021, which is India Resurgence ARC Private Limited versus Amit Metallics Limited, and this was in the case of a corporate debtor called VSP Udyog Private Limited. So I will just briefly say in this case that the India Resurgence ARC Private Limited, it was having a security interest of about 12 crores, and the voting share was only 3.94 crore. So in the resolution plan was approved by a total percentage of 95.35%. However, this 3.94 plus some of the other people, they did not vote for the resolution plan. And in the resolution plan, this particular issue was to be decided by the Supreme Court, because in the resolution plan, the feasibility and viability was seen by the committee of creditors. However, the value of the security interest was not given to India Resurgence ARC Private Limited. According to them, they were only offered about 2 crores in the resolution plan. Their value of the security was 12 crores. So therefore, they were fighting up to Supreme Court that the interest of the dissenting creditor should be protected. The liquidation value of the security interest of India Resurgence was 12 crores. They are being offered 2 crores in the resolution plan. So they were demanding that we should be given 12 crores. So therefore, the resolution plan is not appropriately approved and it should be rejected. Now, the issue before the Honorable Supreme Court was whether considerations regarding feasibility and viability of the resolution plan, distribution proposed with reference to order of priority amongst creditors as per statutory distribution mechanism, including priority and value of security interest of secured creditors, are matters which fall within the exclusive domain of the Committee of Creditors for consideration. Now, this is actually a very, very important judgment, because now also there are many dissenting creditors, or there are many other creditors who has a larger security and they are being offered less amount. They are saying that our security value is larger and the amount which is being offered to us is much less. However, in this case, it was held that all the creditors, all the secured creditors were offered a similar amount. It was a proportionate amount was offered. And I think this, the rationale behind this judgment, India Resurgence ARC versus Amit Metallics, is that the interpretation of Section 53 is still pending before Honorable Supreme Court. The last judgment that has been received in the case of Technology Development Board versus Anil Goel, that was also regarding saying that once the security interest is relinquished in favor of the liquidation estate, thereafter all the secured creditors will be entitled to a proportionate amount. Now, in this particular case, India Resurgence argued before the court that the resolution plan failed the test of feasibility and viability, as the security interest was not taken into consideration. I believe feasibility and viability has got nothing to do with the security interest. Feasibility and viability is that whether the resolution plan has been can be implemented or not. The COC has to ensure, because Section 30 subsection 4 talks about the COC has to assure the order of priority amongst the creditor, and shall also be the value of security interest of the creditors. So the COC has not acted accordingly. The decision of the NCLAT in this case, the NCLAT in fact referred the decision of Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta, and referred that concept which was held in Committee of Creditors of SR Steel Limited, the concept of equitable treatment of creditors, including the observations that equitable treatment of creditors meant equitable treatment only within the same class, and that protection of creditors in general was important, but it was also imperative that the creditors be protected from each other. So this was also used by NCLAT. NCLAT further made observations that Section 30 subsection 4 of the code provides that the COC may approve the resolution plan by a vote shall not be less than 66% of the voting of the creditors. On the plain reading of this provision, it is manifestly clear that the consideration regarding feasibility and viability of the resolution plan distribution proposed with reference to the order of priority amongst creditors as per the statutory distribution mechanism, including priority and value of the security interest of the secured creditor, are matter which falls into the exclusive domains of the COC for consideration. Section 30 subsection 4 in fact vests a discretion in the Committee of Creditors to take into account the value of security interest of the secured creditor in approving of a resolution plan. It's a guideline and not imperative in terms. It may be taken into account by the Committee of Creditors in arriving at a decision as regard the approval or rejection of a resolution plan. Such a decision being essentially a business decision based on commercial wisdom of the Committee of Creditors. So the Supreme Court has said, and also the NCLAT also finally observed, that this Section 30 subsection 4 is a guideline. to the committee of creditor. However, their commercial wisdom has to be seen. Secondly, the dissenting creditors will get more is not something which can be considered as the intent of the legislation. The dissenting creditor will get the liquidation value, and the liquidation value is being distributed to all the secured creditors. So therefore, there is nothing wrong in this. The pleadings before the Supreme Court also, and then like we will only say what exactly the conclusion was. The Supreme Court concluded in this case that the resolution plan has to be feasible and viable. It shall also be proportionally equal in the amount of ratio for the creditors belonging to the class who are similarly situated. If the amount receivable by each creditor is decided only on the basis of the value of security interest, leaving out other factors to be considered in making a resolution plan, it will become irrational and unjust, may not lead towards resolution and maximization of the value of assets of a corporate debtor. The Supreme Court has therefore rightly disregarded the plea of secured creditor. The Supreme Court has therefore rightly disregarded the plea of secured creditor, insisting on higher amount in the resolution plan based on the value of security interest held by such secured creditor. So this was the judgment which, in fact, there are three important judgments which, in fact, used to consider as not really acceptable as far as the intent of the IBC was. One, that the dissenting creditors should get the value of their security interest, and it should not be proportionate to the other secured creditor. This was the original intent. And the Amit Metallics, in fact, was the case where it was, in fact, held differently. Similarly, Vidarbha Power Industries, and other was the Rainbow Paper. So there are three judgments, in fact, which was being talked at various forums. These judgments I thought that I should cover, and now we move on to the other judgment, which is regarding the corporate guarantee. So this is a case where the K. Parmasivam versus Karur Vyasya Bank Limited. This was the judgment of Supreme Court dated 6th of September 22. So in this judgment, the issue, the basic issue is that whether this what is a corporate guarantor, and whether the corporate guarantor can be proceeded against while the main borrowers are not being proceeded against. So there is a company which is Maharaja Theme Parks and Resorts Private Limited, and this company has given corporate guarantee to Shri Maharaja Refineries, Shri Maharaja Industries, and Shri Maharaja Enterprises, and all these three are not private limited companies. These are not corporate entities. So the loan was given to non-corporate entities, whereas the guarantee was given by a corporate entity. So these are the facts of the case, and all the three borrowers, they failed to repay, and Section 7 was proceeded against the guarantor, which is the company, because see, there is no insolvency process which is started for partnership firms or proprietorship firms. Therefore, the borrowers were either proprietorship firm or a partnership firm. However, the guarantor was a private limited company, which is Maharaja Theme Parks and Resorts. So the creditors proceeded against the guarantor, and this was the basic issue. And the NCLT admitted the application, and then the application was challenged, and CLAT upheld the position of the NCLT and dismissed the appeal. Now NCLAT order was challenged under Section 62 before the Honorable Supreme Court, and the issue which was supposed to be decided by the Honorable Supreme Court was this one: whether the liability of the corporate guarantor is coextensive with that of the principal borrower, that is the Maharaja Theme Parks and Resorts is a corporate guarantor as mentioned under Section 5, subsection 5, capital A of the IBC, and is responsible for the payment of debt to the financial creditor. So that means it is a coextensive liability between the borrower and the grantor. The borrower was not corporate entities, so no proceedings under under IBC was started. However, the grantor was a corporate body, so therefore the IBC started against the grantor. The appellant said the corporate person is the one who owes a debt to any person, and the appellant was not a corporate person because this company, Maharaja Resorts, this company had not taken any loan. Because the definitions of section 5 subsection 5a and section 3 section 7 and 8, these were all kind of part of the discussions, and it was further argued before Honorable Supreme Court that it is apparent that a corporate grantor is a surety in a contract of guarantee to a corporate debtor. The borrower is not being corporate debtor. So the wording here, their argument is wrong here, because the contract of guarantee to a debtor, not a corporate debtor, to a debtor. So therefore, these three entities were debtors. The respondent, in fact, took the benefit of Lakshmi Path Surana versus Union Bank of India. That was the judgment of Honorable Supreme Court on 26th of March 2021. In that judgment also, it was held that the CIRP can be initiated against a corporate entity who has given a guarantee to secure the dues of a non-corporate entity as a financial debt accrues to the corporate person in respect of the guarantee given by it. Once the borrower commits default, the guarantor is then the corporate borrower. Then the guarantor becomes the corporate borrower, corporate debtor. The observations of Honorable Supreme Court is, prima facie, it appears that the observation was that the NCLT and NCLT orders were right. The Supreme Court could not find any ground to interfere in their decisions. The financial creditors can proceed against Maharaja Theme Parks and Resorts Private Limited. And basically the reliance was placed on the decision of Lakshmi Path Surana versus Union Bank of India. So the case was concluded in favor of the corporate grantor, in favor of the NCLT, in favor of the creditor. Whatever decision they had taken, it was right, and it can be proceeded against a corporate guarantor. It was a corporate guarantor because the corporate guarantor becomes the corporate debtor. Finally, the principal borrower can be corporate or non-corporate entity, thus giving a greater scope of relief to financial creditor and preventing the corporate guarantor or debtor to escape from the obligations. So then we move on to another judgment, which is basically on moratorium, and the moratorium is regarding the kind of custom dues during the moratorium period. Central Board of Indirect Taxes and Customs. This was the case filed by Sundaresh Bhatt, who was the liquidator of ABG Shipyard, and the Central Board of Indirect Taxes, CBIC, was the respondent. The judgment was dated August 2022. So this particular judgment, again, in August 27, in August 2017, the liquidator informed the respondents of the initiation of CIRP and sought custody of the warehoused goods and requested the respondent not to dispose of or auction the same. So the goods were imported by ABG Shipyard, and the goods were invoiced to ABG Shipyard. Based on the invoice, the ownership of the goods lies with the ABG Shipyard. However, the goods were in the custody of Customs Department because the custom duty was not paid by ABG Shipyard. In the meantime, the CIRP started, and the liquidator RP provided this information that the CIRP has started and you provide your claim. However, the claims were not coming, and then the liquidator filed an application before NCLT for passing an appropriate order and seeking the custody of the goods imported by ABG Shipyard. And finally, the liquidator had an intention of taking the custody and selling it. Then the Customs Department filed their claims for the goods warehoused at Gujarat and Maharashtra, and this was the facts of the case. And the total claim of the Customs Department was about 763 crores, and there were many bill of entries. In fact, the scenario was that the liquidator wanted the custody. Now, the Supreme Court, in fact, was basically deciding on two issues: whether the provisions of IBC would prevail over Customs Act, and if so, to what extent. Second, whether the respondent could claim title over the goods and issue notice to sell the goods in terms of the Customs Act when the liquidation process has been initiated. So this was the judgment which came in favor of the liquidator, and the observations of the Supreme Court was that insofar as respondent authority only has a limited competence to determine the quantum of the custom duty and other levies once a moratorium is imposed in accordance with Section 14 or 33 subsection 5 of the IBC, as the case may be, the IBC would prevail over Customs Act. According to the Customs Act, respondent authority lacks the authority to begin the sale, because the normal process is that in case anyone is not able to pay custom duty, then the custom authorities has a right to sell or confiscate the goods and then finally auction it and recover their custom duty. And in case the value realized is more than the custom duty, and then the balance, either the entire material would not be sold, or the balance is payable to the importer. So then it was also mentioned by Supreme Court that Section 142 capital A of the Customs Act states that except with respect to the cases under Section 529A of the Companies Act, 529A is the earlier winding up processes, then the Recovery of Debt and the Recovery of Debt Act, now this is Recovery of Debt and Bankruptcy Act 1993, SURFACI Act, and IBC Act, the custom authorities would have first charge on the assets. So in fact, the IBC was also an exception when this charge on the asset was being considered by the Customs Act. So it was also very clear that even the Custom Act also would give way to IBC in case of any kind of conflict. Section 238 of the IBC was also used. Now the other issue is that whether the Customs Department could sell the goods or not. So in this case, as far as the respondent is concerned, it only has a limited competence to assess the custom tax and levies once a moratorium is imposed, and the moratorium period would continue even if the company goes into liquidation. According to the Customs Act, the respondent authority lacks the ability to begin the process of recovering debt through the sale of goods. Therefore, the IBC would prevail over the Customs Act. Following such an assessment, the respondent authority must present its claim to the adjudicating body in accordance with the established procedure and the strict compliance. In any case, the IRP-RP liquidator can immediately secure goods from the respondent authority to be dealt with appropriately in terms of IBC. So this was the possession was given, possession was handed over to liquidator. In fact, thereafter, we have also taken multiple possessions from Customs Department, because the Customs Department has accepted this final authority on the law and has started complying with these kind of cases. The next one is again an important judgment, which is Indian Overseas Bank versus RCM Infrastructure Limited. This was the judgment in May 2022. In this particular case, the bank had sold a secured asset before the commencement of CIRP. Bank had taken 25% of the total bid amount, and 8.23 crores was taken. And after that, once this 25% amount was taken after the bidding, then the Section 10 application was admitted by NCLT, and the because see, then the bank, what the bank did, bank also issued sales certificate. Bank also issued sales certificate before the commencement of CIRP, because the sales certificate is an internal issue by the bank. So, however, the sales certificate is never issued unless the full amount is paid. However, in this case, the sales certificate was also issued where the 75% of the payment was pending. And after the CIRP, the bank took 75% balance amount from the bidder and then revised their claim before the RP, reducing that amount, whatever they have recovered. So therefore in fact, the promoter in fact filed an application to NCLT, and the NCLT and NCLAT, you see, the promoter therefore filed an application praying the NCLT to set aside the security realization during CIRP period carried by the appellant, or in an alternative to cancel the transaction. NCLT allowed the sale application, and the appeal filed by the bank, Indian Overseas Bank, because the Indian Overseas Bank had realized the money, the appeal was also rejected. Now, the Honorable Supreme Court, in fact, had to decide these issues, whether the act of foreclosure under SURFACE is prohibited on the initiation of the moratorium under IBC. Do the provisions under the IBC prevail over the other similar laws in the country? Whether a sale-wide auction is said to be completed on payment of partial consideration. So the section moratorium in any case specifically mentions the SURFACE Act. Therefore, it was relied. Section 238 was also relied in this case. Security realization during CIRP, the provisions of Section 14 moratorium, where the SURFACE is also mentioned very clearly. So these are the law which was being relied. The argument was that the sale was complete. The Indian Overseas Bank said the sale was complete, and again said that the Section 54 of the Transfer of Properties Act, merely because of the part payment was received subsequently after initiation of CIRP, it will not deprive the appellant from receiving the said property. So the Section 54 of the Transfer of Properties Act was also used by the appellant. Also, the Sakina and others versus Bank of India case arising out of the SURFACE Act was also used by the appellant. So, however, the respondent said that the sale would be governed by Rule 8 and 9 of the Security Interest Enforcement Rules 2002. The sale would be complete only when the auction purchaser makes the entire payment, and the authorized officer exercising the power of sale shall issue a sales certificate of the sale of the property. In the present case, the balance amount was received after the CIRP commencement. So the Supreme Court held that the moratorium under Section 14, and it's a complete prohibition for any action to foreclose, recover, or enforce any security interest. The wording used in Section 14, which is including any action under SURFACE Act, is very important. Section 238 is very important. Therefore, the appellant bank could not have continued. The appellant bank, like Indian Overseas Bank, could not have continued the proceedings under SURFACE Act, and the moratorium was, the bank cannot continue to the proceedings. So therefore, that particular sale was cancelled. that particular sale was cancelled, which was done by Indian Overseas Bank, and part payment was received during CIRP, so that was cancelled. Now there are couple of judgments on limitation law. So because I will just run through these judgments very quickly, just will give you the basics of these judgments, because these judgments are on limitation law, so the concept is now repetitive. So this was the judgment which Asset Reconstruction Company India Limited versus Tulip Star Hotels Limited. So this was again August 22 judgment, and the only issue in this case was that the process started in 2013, where some kind of letters were being issued. The one-time settlements were also being explored, and some settlement agreement was also being explored. So in all these cases, the observations of the Supreme Court finally is that the IBC is a beneficial legislation for equal treatment of all creditors and also the protection of livelihood of its employees. Citing the case of Seshnag Singh, Baidyabati Shiropoli Cooperative Bank Limited, the Apex Court stated that the legislature, that is the section 238A, this was inserted to say that the limitation law is applicable as far as may be. That was the wording used in section 238 capital A when it was inserted in the code. Has in its wisdom chosen not to make the provisions of Limitation Act verbatim applicable to proceedings in NCLT, NCLAT, but consciously use the words as far as may be. The court would not give an interpretation to those words which would frustrate the purpose of making the Limitation Act applicable to proceedings in the NCLT, NCLAT as far as may be. It is therefore imperative that the provisions of the IBC be construed liberally in a purposive manner to further the objects of the enactment of the statute. Section 18 of the Limitation Act, an acknowledgement of present subsisting liabilities made in writing in respect of any right claimed by the opposite party and signed by the party against whom the right is claimed, has the effect of commencing a fresh period of limitation from the date on which the acknowledgement is signed. Such acknowledgement need not to be accompanied by a promise to pay expressly or even by implication. However, the acknowledgement must be made before the relevant period of limitation has expired. So this is something which is the acknowledgement of debt. Maybe it is by way of a settlement agreement, maybe it is by way of a separate letter. That was considered to be commencing a fresh period of limitation of 3 years. To the Bengal Silk Mill Company versus Ismail Ghulam Hussain Arif, the court opined that the balance sheet contains the admission of liability. The agent of the company who makes and signs it intends to make those admissions. The admission do not cease to be acknowledgements of liability merely on the ground that they were made in discharge of a statutory obligation. So finally it was held that the entries in the books of account or balance sheet of a company can be treated as an acknowledgement of a liability in respect of debt payable to a financial creditor. Accordingly, it was held that the corporate debtor acknowledged its liabilities in its financial statements from the year 2008-9 to 2016-17. Thus, the CI application was well within the period of limitation. Therefore, the unclad judgment were in fact unclad judgment was quashed. Now, another judgment on limitation law is State Bank of India versus Krishidan Seeds Private Limited. Again, this judgment came in April 2022. In fact, this year 2022 was much vocal on limitation law. Multiple judgments came, and this was also a similar judgment where the total credit facilities of 102 crore, and it was again a judgment where the Honorable Supreme Court has said that the acknowledgement in a balance sheet without a qualification can be used as to whether the period of limitation would stand extended or not. So there, for the first time, it has been used that the acknowledgement in a balance sheet without a qualification. So the Supreme Court said that the balance sheet without a qualification can be relied upon for the purpose of proceedings under IBC. The Supreme Court held that the unqualified acknowledgement of debt in corporate debtor's balance sheet within a period of 3 years from the original date of default extends limitation for filing CIRP under Section 7 of the IBC. Section 238A, which was inserted in the code of IBC, makes Section 18 of the Limitation Act applicable to the proceedings under IBC. Therefore, the provisions of Section 18 of the Limitation Act are not alien to and are applicable to proceedings under IBC. Second, an acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended, so long as the acknowledgement was within a period of 3 years from the original date of default. With the above clarification, Supreme Court allowed the appeal and set aside the impugned judgment and the order of the NCLT and NCLAT. Now, this another judgment which is on limitation, but this limitation is different. So we have seen a limitation, which is the limitation as the any kind of acknowledgement. That acknowledgement can be by way of a settlement agreement. That acknowledgement can be by way of saying that we have to pay something and we want to settle it. That acknowledgement can be by way of a payment. That acknowledgement can be by way of an entry in the balance sheet. That acknowledgement can be by way of an entry into the books of account. And now, but this is a different kind of a limitation. And in this case, Sapphire Technologies Private Limited versus Regional Provident Fund Commissioner. It was a judgment in April 2022, which is a limited petition for filing an appeal. So in this particular case, the Regional Provident Fund Commissioner, in fact, they filed a kind of appeal before the NCLAT. They filed an appeal. So this is a corporate debtor was Maruti Kotsu Cylinders Limited, and it was initiated, CIRP was initiated in April 2018, and the COC approved resolution plan in October 2019, and later on a claim was received. A claim was received from Provident Fund Department, and it was not taken into account since the resolution plan had been approved. Therefore, the NCLT issued notice in appeal. NCLAT issued notice in the appeal. Thereafter, because see, NCLT, in fact, beyond, it was an appeal filed beyond 45 days. It was an appeal filed beyond 45 days. NCLT, in fact, issued notice looking like not considering the delay in filing the appeal. Therefore, this Sapphire Technologies Private Limited went to Hon'ble Supreme Court, and it was decided by the Hon'ble Supreme Court that this timeline given under Section 61 of the IBC has to be interpreted strictly. And that's what the contentions in any case was, because this is a very small issue. That issue is that whatever timeline provided in Section 61 of the IBC, and the appellate authority has the power to extend the period of limitation only by 15 days, because the original time period is 30 days. The appellate authority can extend it by another 15 days, and beyond that, it should not be done. That's what has been the decision. Now, another limitation law judgment is New Delhi Municipal Council versus Minosha India Limited. It's again a limitation law to exclude IBC proceedings. So in this particular case, a company which is Minosha India Limited filed an arbitration proceedings against New Delhi Municipal Corporation, and the New Delhi Municipal Corporation said that it is already barred by a limitation law. So, however, in this case, the New Delhi Municipal Corporation lost because it was held that it is very clearly written. It is very clearly written in the Section 60, subsection 6, that if the entire period of insolvency would be excluded for the purpose of any limitation for filing any appeal or filing any application or filing any arbitration application. So therefore, it was held in this case that this limitation, whenever we decide about limitation, now think of a situation that a corporate debtor is entitled to file an appeal for recovery of some dues. Now, the RP could not do that. And finally, when the a liquidator starts doing something, and the respondent might even say that this now the particular debt is time barred. So this the court has held that this period of CIRP and the liquidation, that should be excluded while we determine the limitation period for any company which is under insolvency. So this was the observation. The observation, in fact, is very important, that we all should, because we would be needing this, because see, there are many scenarios where we try to recover some amount, and but it is somehow the limitation law is over. So we have to see the time of moratorium under Section 14, that should be excluded. That's what this judgment is. So that period would be excluded for any litigation on behalf of the corporate debtor. So where the corporate debtor is entitled to something, that should be excluded. Again, another law, which is SV Fashions Private Limited versus Ritu Murali Manohar Goyal. This is again a limitation law. So when the returned check, and because the checks were issued in this case, the checks were returned, so that kind of background was also covered under Section 18 of the limitation law, and the NCLAT, an entry in the balance sheet of the company could be treated as an acknowledgement in writing under Section 18. Again a similar law, and finally it was also held to be very apparent that this limitation law is applicable. However, the extension of the limitation period can be seen in many manners, like last payment made, any acknowledgement in writing, any kind of settlement agreement, any kind of one-time settlement, any kind of arrangement, any payment, balance sheet entry, books of account entry. So all these are basically extending the limitation period. Now the judgment, which is it is in July 22. This is SS Engineers versus Hindustan Petroleum Corporation Limited. So in this particular case, the facts were that this particular contractor, SS Engineers, and the Hindustan Petroleum, there was a work contract, and there were some disputes, and based on all those disputes, the Section 9 application was filed against Hindustan Petroleum and as against HPCL Biofuels. It's a wholly owned subsidiary of HPCL. Then the NCLT saw the dispute, and the application was admitted under Section 9 on the basis that the claim default is for higher amount and the dispute is lesser. So the NCLT said that the total claim is, say, 10 crores and the dispute is only for 1 crore. So they admitted the application, and the NCLT also, the honorable the appeal filed by the HPLC and set aside the NCLT order. However, NCLT reversed it. So first, NCLT accepted that if there is a claim of 10 crores and there is a dispute of 2 crores, that means that the balance 8 crore, it can be used for initiating CIRP. NCLAT said no, the adjudicating authority is not here to decide what is disputed and how much is disputed and how much is not disputed. What is required under Section 9 is that it should be a very clear, undisputed claim, and it should not be a claim where part of the amount is disputed and part of the amount is undisputed, because it is not the jurisdiction of adjudicating authority to decide on the disputes. So the issue before the Honorable Supreme Court was that whether it is the duty of the NCLT to adjudicate the disputes between the parties and determine whether in fact any amount is due from the operational creditor or vice versa. So in this case, the observation of Honorable Supreme Court was NCLT exercising powers under Section 7 or 9 of the IBC is not a debt collection forum. IBC tackles and or deals with insolvency, it is not the object of the IBC that the CIRP should be initiated to penalize solvent companies for non-payment of disputed dues claimed by an operational creditor. There are noticeable differences in the code between the procedure of initiation of CIRP by a financial creditor and initiation by an operational creditor. On a reading of section 8 and 9 of the code, it is patently clear that the operational creditor can only trigger the CIRP process when there is an undisputed debt and a default of payment. Therefore, if the claim of an operational creditor is undisputed and the operational debt remains unpaid, CIRP must commence. The code does not countenance dishonesty or deliberate failure to repay to the operational creditor. However, if the debt is disputed, the application of the operational creditor for the initiation of CIRP must be dismissed. In this present case, it was a pre-existing dispute case, and NCLT has rightly allowed the appeal, so no interference was required. Now, again, on a limitation law, the Invent Asset Securitization and Reconstruction Private Limited versus Girnar Fibers Limited limitation law. Again, the date again is the April 2022, and again the limitation law, where the present Section 7 application is barred by limitation. So it was again based on the various other decisions. Time and again, it has been expressed and explained by this court that the provisions of this code are essentially intended to bring the corporate debtor to its feet and are not of money recovery proceedings as such. The intent of the appellant had only been to invoke the provisions of the code so as to enforce recovery against the corporate debtor. We find no fault in the NCLT and NCLT tribunal having declined the prayer of the applicant, accordingly dismissed the appeal of the invent. In this particular case, the facts were that the NCLT noted that the right to sue arose on the date of NPA was declared on February 22, 2002, but there was no indication of an admission of liability by the corporate debtor under Section 18 of the Limitation Act. So this was again a Limitation Act. So then we have a judgment which is, I will just quickly take it, Walal RCK versus Siva Industries and Holding Limited. In this judgment, the IDBI initiating CIRP against the corporate debtor, and the same was admitted. The promoter filed a settlement application. So in this case, it was held that the settlement plan, which is submitted with the approval of 90% of the COC. Now the NCLT says that it is not a settlement plan, it is a kind of business restructuring plan. So therefore, the NCLT rejected that withdrawal application. Finally, the Supreme Court said that the COC has all the commercial powers. Section 12A can be used. 90% of the voting, if can be achieved, then the kind of settlement, the kind of resolution, the kind of payment, that is not to be seen by the adjudicating authority. The powers of the committee of creditors to approve any kind of business restructuring plan, settlement plan, withdrawal plan, that is all within the powers of the committee of creditors. And the NCLT and the appellate authority cannot sit on the commercial wisdom of the committee, whether it has to be permitted or not. So another judgment where the Noida and the Greater Noida Authority has been held as an operational creditor, that has been much talked about because they are the operational creditors, they are not the financial creditor. And this judgment was fought by AAA. Anand Sonbhadra is a partner of AAA. So the judgment was in fact much detailed, and it was on the accounting standards and the accounting concept of financial lease and the operational lease. So it was the kind of land which is given by Noida Authority or Greater Noida Authority on lease, and this was held to be an operational. This was held to be a operational lease and not a financial lease. So this was the judgment. And the last is the Sunil Kumar Jain versus Sundaresh Bhatt. And this in this judgment, it is regarding the workmen. When we start a CIRP, it has been held in this case that it is the duty of the RP to see how many workers are working with the company, whether this kind of whether they are needed or not, and in case they are needed, then only the CIRP cost would be considered and approved. But in case those workers are not needed and they are simply on the roll and the company is not a going concern, then those salaries would not be considered as CIRP cost. So this actually is a clarity on very big dispute, which was seen in the Jet Airways, which was seen in the ABG shipyard, where the huge workforce claimed salaries and wages during CIRP period, and those salaries and wages in fact was much more than the total assets of the company. So this was also a very landmark judgment, which in fact gave a lot of solace to the process. Now the IP remuneration has also been a very big judgment, very good judgment. Devarajan Raman versus Bank of India Limited. In this case, it was in January 2022. In this case, the case was withdrawn by NCLT, and the RP claimed his fee, and the NCLT did not approve some part of it. Then the NCLT approved ad hoc amount of 5 lakhs of rupees as the fee, and finally the Supreme Court said that it is not the commercial wisdom of the COC. So the observations of the Honorable Supreme Court: after NCLT set aside the order of NCLT initiating the CIRP, the proceedings were remitted back for determining the cost, CIRP cost. The court materially noted that the appellant had addressed a letter to the respondent prior to filing of the application, to which the respondent, upon verification, had stated that the cost and fees were in conformity with both the technical and financial bid based on which the assignment was awarded. Further, in the application which was filed by the appellant before the NCLT, the appellant annexed a statement of costs, the amount which was reimbursed with the balance dues. However, the order of the adjudicating authority reveals that none of the submissions of the appellant were considered. NCLT merely directed the respondent to pay the expenses incurred and an amount of 5 lakhs plus GST towards the fee. Neither the basis of the claim nor its reasonableness was considered by the NCLT. Further, the NCLT merely proceeded in an ad hoc manner on the ground that an amount of 5 lakhs as fee, in addition to the expenses, appears to be reasonable. The apex court stated that both the orders suffered from an abdication in the exercise of jurisdiction and in the absence of any reasons in both the orders. It is impossible to deduce the basis on which the payment of rupees 5 lakhs together with expenses has been found to be reasonable, and an order of remand becomes necessary. So in this particular case, in view of the above, the appeal is allowed, and it is being set aside to NCLT for making a fresh decision and direct the LCLT to dispose of the appeal within 1 month. So that was the kind of scenario that in fact appeared in this case, that some kind of ad hoc decisions were taken by NCLT and NCLAT regarding the fee of the IRP when the CIRP process was quashed by NCLAT. So in this case, Bank of India fought, and they were not paying the full fee as agreed by the bank through letters. So this was a relief given by Honorable Supreme Court. So we are through with our Supreme Court judgments, because today's maximum judgments were seen. In fact, it was for limitation law. All kinds of limitation law was covered. We have covered most of the landmark judgments of Honorable Supreme Court. In this coming Saturday at 11 a.m., we would delve on the proposed amendments as per the notice inviting comments by Ministry of Corporate Affairs. We will delve on that. So we conclude the session, and in fact, let me see in case there are any questions. So I think this is a very important question. One question that has come is from Ashok Kriplani. It says what is qualified and unqualified acknowledgement of debt shown in the balance sheet. Now, I think the qualified and unqualified means that in case we say that these are the liabilities of the company, and we also say that these are the liabilities are disputed, these liabilities are disputed, and in case we qualify these liabilities in the balance sheet itself, in the notes or anywhere, then it becomes qualified acknowledgement. So if that acknowledgement is qualified, then I believe the limitation would not act, because it can be said always that although the amount is not payable, but however we are keeping in the balance sheet only because the litigation is going on. And then it is what is the limitation period for filing an application under section 95 of the IBC against the personal guarantor of the CD? The limitation period of for a personal guarantor starts from the date of invocation of the personal guarantee. So in case the bank guarantee is invoked today, the period of limitation will end after 3 years of the invocation. And in fact, there are two scenarios. One is the invocation of the guarantee, and within 30 days it has to be paid. Only then the default starts. So that 30 days also has to be included in the because the limitation period only starts when the default starts. So default would be considered after 30 days. So I think it was like another question which is coming from Rohit Vora is that in this case of Bank of India. So it's like, let me repeat what was the case of Bank of India. In fact, the Bank of India agreed for a fee as per the normal process of selecting a IRP or RP by the banks. The CIRP initiated, and finally the NCLT quashed the CIRP. Thereafter, the Bank of India was saying that the fee that you are claiming is not right because some part of it was basically the litigation part. So, however, the Supreme Court says that NCLT, first of all, did not approve any fee. NCLAT approved a fee of 5 lakhs. Then the Supreme Court saw that there was a fee which was agreed by the bank, and that all those documents and letters were found. After that, it cannot be held that since it was the ad hoc decisions cannot be taken, so it was reverted back. The entire case was reverted back to NCLT with the direction to decide it within 1 month. So again, MR Gukada says that OC sent email for payment due. Based on this, limitation period can be considered. OC sent email for payment due. No, I think the OC sent email for payment due, that means the operational creditor has sent the email, but not the company. The company has not acknowledged. Anything which is from the other side cannot be considered as extension for the limitation period. Like if the company has to acknowledge that, not the creditor has to acknowledge. The creditor will always acknowledge. The creditor will not have any difficulty. Jayandrayan Gupta says that if neither the erstwhile RP nor the COC members ratify your unapproved expenses during CIRP, but they also do not state whether those expenses were avoidable or not, what stand the liquidator should take if they claim the same as CIRP expenses, that the rent or executive salary? No, I think this is again based on the facts. One, I am saying that as far as this Neil Kumar Jain versus Sandesh Bhatt say that as far as the salaries are concerned, it has to be approved by the committee of creditors, and the RP has to present it before the committee of creditors that they are working for the company, or they are working for the company as a going concern, or they are assisting the RP in the process. So these are the 3 reasons that the salary of the workman or executive can be approved and can be considered as CIRP cost. As far as this fee is concerned, now there is no issues. As far as the quantum of the fee, there is a minimum fee which is stipulated by IBBI. So, but that is applicable only till the application for liquidation is filed, or application for an approval of resolution is filed, or application for withdrawal of application is filed. So these are now not the matters of dispute, but the expenditures are. If the expenditures are incurred and the expenditures are not approved, I think then the adjudicating authority will use its own powers, where the expenditures can also be claimed in case these are justified and as per the process. Then if the limitation period not satisfied, can we update claims with NCLT? Yes, the RP has the power, RP or the liquidator has the power to update the claims in case you find that some of the claims have been filed which are limited, which are barred by limitation law. Then you can reject those claims based on the limitation law, and then you can file a revised list of creditors to the adjudicating authority. So this is all for today. Thank you very much, and do write to us in case please come prepared the next time that we are having a session on the proposed amendments. Thank you very much. Thank you very much.